Here, this matter is revoked.
Judge, it's clarification. Is the bond $2,000, 10%?
Yeah, that's gonna be a problem.
Court calls the case, People versus Kayla Berkshire.
Well, he's uncovered.
Good morning, Rob Jacob on behalf of Ms. Brookshire.
Marie Berkshire.
Judge State's PCC, we're asking this matter for a preliminary exam. And I would,
Discovery is complete.
yes, Your Honor. I met with her at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it. And I believe that's the violation itself. We're asking if the court would please consider just to really restore it back to PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it. It doesn't work. So we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail. So okay. I just think the tether people have to either come and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160, and I had my dad looked at it and we both double checked. And he couldn't see it. He put the wrong one, but I did leave 2 messages for Brian Levitt. He told me to charge it for 20 minutes. We agreed on 20, I did 35. I called them after to see what my percentage was. I left him a message. And when it was going off, I called him again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. But
I don't have any of that information regarding any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what's reflected in the community corrections violation.
I don't, hang on. I have the sheriff's office report.
I have a bond violation. Community correction.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I gotta figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance, that'd be great.
Yes, Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after leaving corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, this finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, this will be contacted. They acknowledged this and the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to reach the defendant were unsuccessful. At 7:48 p.m., Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond and take the defendant into custody. By Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to be arrested on the violation. the defendant had only charged for a total of 45 minutes in the last 5 days. At
Ooh,
9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is working. In addition to this, my office just charged her with stalking in a
What?
separate case. In addition to this, my office requested a $10,000 cash surety bond at the time of charging this case. This case being today's case, we requested the 10,000 cash surety on putting she's before your honor.
Mr. Kirwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay, motion for bond reductions denied. Bond will continue in this matter as revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on?
No.
I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not gonna sit there and mouth me. Her bond now is 25,000,
Really?
10%. Yeah, really? You want to keep going? I didn't think so. Have a good day.
Court calls case, people versus, is it Hazel Jacobs?
Assistant Public Defender on behalf of Hazel Jacobs, who approaches.
Take Gene.
Mr. Jacobs. Thank you. Your Honor,
Yes.
I'm so sorry. Just looking for my notes on this one. I do know that, Your Honor, if we can be heard on bond after this, I would be appreciative. And I understand that there is an alleged violation that we need to go over. We would like to, you want to waive or hold your exam? I tried to get a hold of my client, Your Honor. I was not able to explain to him because we didn't know that he was in the jail until late yesterday. So I have not been able to talk to him. I would ask to adjourn this for 1 week so I can go over everything with him and explain exactly what the next options are. So if we could just get 1 week, that'd be, I wouldn't,
June 20th, 2000.
not right now. Stop talking. Listen, I have the information.
June 24th, 2020. June 20th, 2024, 9 a.m. for probable cause.
Thank you, Your Honor.
This time you want to address, you didn't want to address bond, did you? I have a conditional violation. If you want to address it, you can go ahead, but
I understand, Your Honor. As it pertains to the conditional violation, my client would have me advise the court that with regard to the report that the court is in receipt of, the argument involving the subject of the no contact order, which was heard by his neighbors, occurred while he was not home, occurred while the individual he has the no contact on was arguing with someone that she was talking to the phone on. He advises that she was at home without his knowledge and that he came home to find her there. It advises that the ensuing argument resulted after she started screaming and crying when he asked her to leave so he wouldn't violate his conditional bond, Your Honor. Additionally, he advises that he has orientation for a new job next week and he will be unable to gain income used to support his father and child if he loses that new job, which will happen if he does not attend that orientation. So he would be asking for a release based on the information that the court's in receipt of.
response from the people.
He was home. He told the police that he was home. He actually told the police that she's the person he was arguing with. He actually went on to tell the police that he's the person she was yelling at. I'm not sure why he doesn't remember talking to the police. I'm not sure why he doesn't know that the police would write a report to that. That all of us have this report, including all of his admissions to be and having contact with her. So yes, this occurred at his apartment. However, he was there. The police spoke with her and spoke with him. And the police arrested him for having contact with her. And that's when he went on to admit to them that he was in an argument with her, that she was screaming at him, and he acknowledged the no contact order with her. So that's the conditional violation. The other reason that Your Honor should continue the defendant's bond as it currently is ordered is because when my office charged this case, we requested 25,000 cash surety on this, and we're not given that information. This is a case where the defendant is charged with strangulation, reported to the police. The defendant was punching her in the face, got on top of her, while she was laying on her back on the bed. The defendant was on top of her, pinning her arms on the bed and using his other hand to choke her. She told the police that the defendant squeezed her throat with his hand, and then started using the blade of his forearm, so it has the bone there, to apply pressure to her throat. She said she punched him in the face in an attempt to get him off of her, and that she felt that she was being choked for approximately 30 seconds while she struggled to breathe. The police noted in their report that the victim's throat was covered in scratch marks and red bruising. She indicated she did not lose consciousness, but she had to fight him off on her bed. And then the defendant, while she was trying to fight him off of her, the defendant went on to bite her right shoulder. The police officer wrote in the report, I observed what appeared to be an obvious bite mark on her shoulder, visible teeth marks and bruising. It goes on. The victim continues to report that even after that, punching her in the head, the officer does a great job of, as she's reporting what occurred to her, keep that in his next statement. He's on to report what he observed. He says, I observed raised bruises or goose eggs on the side and back of her head. And it continues. So, Your Honor, we requested $25,000 just based on the facts of this case alone, as well as the danger that the defendant presents to not only this victim but the community. But then he goes on to have contact with her, make admissions to the police, and come before Your Honor and try to tell us a different story. So I'm asking that Your Honor not reduce bond in any way this time. Thank you.
Your Honor, may I respond to that?
No.
Your Honor, as it pertains to the allegations of the alleged crime here, a determination was made by the magistrate as to his release. He was out. We don't deny, as it pertains to the allegations on the bond violation, that any of that happened, other than the fact that he arrived home from a haircut and she was there and he tried to get her to leave, so that he wasn't in violation of that bond condition. He advises that he has a tether. He's willing to do home confinement. We just would ask for consideration and his release.
No, he was brought in on the conditional bond violation. It was not arraigned before the magistrate on the conditional bond release.
I'm sorry. I didn't mean to cut you off. I'll stop talking.
Go ahead. What were you gonna?
I was just with regard to the original charges, Your Honor, not the bond violation.
Right.
Okay.
Taking all that into account, what the story that just relayed to me doesn't match the police report at all. In regard to what the defendant is having counsel put forth to the court.
Okay.
Because of the the conditional bond violation, taking that into account with the allegations, at least as it regards this particular case, the court's going to set the defendant's bond in the amount of $50,000 cash surety. And we'll see him next week.
Thank you, Your Honor.
Mr. Ganacher, please.
Good morning, Your Honor. Mr. Knapp, Senior Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to create a conflict between this honorable court, the Office of the Public Defender. The Prosecutor's Office does not believe the conflict exists, but if there is one present, we waive all the cases today between my office and the Public Defender's Office before this honorable court. Thank you.
Thank you, sir. Mr. Brown.
Good morning, Your Honor.
Good morning.
Gordon Brown, Deputy Chief Public Defender, appearing. Your Honor, we likewise do not believe that any conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we waive that conflict so that this honorable court could hear these matters.
Thank you, Mr. Brown. Court, for its part, also does not believe there's a conflict either in the court rules or the cases to set there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case People of the State of Michigan versus Maurice Anthony.
Mr. Ganatra on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Davi Liba on behalf of Mr. Anthony. Mr. Anthony, could you state your name, sir?
Maurice Anthony.
Thank you, sir. What are we doing?
Your Honor, today will be requesting an adjournment in order to review discovery with Mr. Anthony.
Where are you located? You're in Livingston.
Yes.
Preliminary exam. How long do you, Mr. Anthony, how long are you going to be in there? Do you know?
Just to tomorrow.
Just till tomorrow? Okay. Then what I'll do is I'll set it out to the 2nd.
PCC, Your Honor.
Yes, for PCC. I'm sorry, not a preliminary examination. Probable cause, July 2nd, 2024. nine AM, or as your invite indicates, bond continues.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case People versus Mark Austin.
Image Ganatra for the people.
3 cases.
The public defender Hannah Apple appearing on behalf of Mr. Austin.
Mr. Austin, can you state your name, please?
Mark Austin.
Thank you.
Your Honor, my understanding is that he still remains incompetent. We did not receive a report regarding an update, so we would ask for an adjournment.
I do have a copy of the report to support, have a copy in its file.
The June 10th report.
The report is dated June 10th, sir.
Yes, sir.
Okay. I can hand a copy to Miss Apple.
Thank you.
I'll actually give it to her because I have an electronic copy. But the people don't have any objections to the adjournment request, but we also agree with the findings of the report. They believe that I'm just giving the thumbnail for Miss Apple's benefit.
All right, but you're not looking to have that happen today.
Correct.
All right. One other issue, and I'm not sure what we do with this because he's incompetent at this point, or at least been determined to be that. He also has an arraignment on a knee charge.
Okay.
That's also assault on a prison employee.
Yes.
Your Honor, I have no objection to adjourning that if that's what counsel wants.
All right. So the competency hearing, I'll adjourn. How long did you want?
Your Honor, 90 days. That's too long.
What are you trying to accomplish within the 90 days, I guess? Are you?
I haven't had a
doing
chance to
IME?
review the report, but if,
Are you looking to make an assessment on an IME?
oh, understand. Your Honor, just 2 weeks so that we can review that.
Oh,
Thank you. Sorry, I was misunderstood. Thank you.
why don't we just do July 2nd, 2024, 9 AM? On that, I'll also adjourn. I'll adjourn both cases and the arraignment to that date.
Understood.
All right. Okay, thank you.
Thank you.
Thank you, Mr. Austin. Court calls the case People versus Michael Fritz.
Andrew Childers appearing on behalf of the people, Your Honor.
Good morning, Your Honor. Leslie Knapp appearing on behalf of the defendant, Michael Fritz. And to my left, state name.
Michael Fritz. He's waiving preliminary examination.
We are, Your Honor. I have explained to Mr. Fritz his absolute right to a preliminary exam, and at this time he wishes to waive it.
All right, Mr. Fritz, you understand that would be a hearing where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 and 3 following. So as to the arraignment on the information, you waive formal reading.
We will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
July 24th at 1:30 before Judge Conlon.
July 24th, 2024. At 1:30. That's before Judge Conlon.
Yes.
Before Judge Conlon.
Thank you, Your Honor.
Thank you.
May I address one issue? Mr. Fritz lives in Plymouth. He has,
Apparently that's yes. Go ahead.
we're just asking that the random drug screens be transferred to Jams in Westland. He's having a problem getting out here for them. His only transportation.
Well, the way that would work is you can contact the prosecutor's office. You
Okay,
can do that by stipulation if they would so agree. An order would need to go over to community corrections. Your client would have to sign a release with JAM so that the result will be reported to community corrections so they could be forwarded to the court and the people as well as defense counsel.
I'll take care of it. Thank you, Your Honor. Great day.
You do the same. Court does call the case People versus Peter Heenan.
Prosecuting attorney Morgan Baroque on behalf of the people.
Good morning, Your Honor. Christopher Whitman, P75395 on behalf of Mr. Heenan, who is walking up with me to the podium, will be standing to my right momentarily.
Your name, sir?
Peter Heenan.
All right, what are we doing?
Thank you, Your Honor. We just substituted in yesterday. We did receive police reports from the prosecutor's office. Appreciate that.
We believe that there might be video of the interviews with the complainant in this matter. We would ask for a brief 2-week adjournment to get those videos and to reset this for PCC at this time.
Any objection from the people?
So, Your Honor, I do just want to note that at this point, all of the discovery that we have has been turned over to defense. I will make an additional request to make sure that that there is no additional videos from Ann Arbor that we are not in possession of, but at this time they have everything.
Probable cause conference, July 2nd, 2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. I do want to briefly address one bond condition. This is an aggravated stalking case. It's alleged my client made contact with his recent ex-wife twice through our family wizard with some unkind words, and then having some items delivered to the home. There was no allegations of any kind of direct threat nor any in-person contact, things like that. He was in jail for 6 days. There was no contact attempted there. He's been out for 8 days. There's no attempted contact there as well. We would ask this court to step down from a home confinement to a GPS with exclusion zones, radius around.
You have to file that as a written motion. I'm not going to hear that at this point in time.
Okay, Your Honor.
I want all the facts before I make a decision on that. Bond continued. Thank you.
Do you want me to set that for a July 2nd date or is further date, Your Honor?
If you get the motion in, give adequate time for the people to respond. We'll reset your probable cause conference likely to the 3 o'clock block, here, your PCC and your motion all at the same time.
Thank you, Your Honor.
For that efficient.
Thank
Thank you. Court does call the case of the people versus Keandre Allen.
Morning, Your Honor. Rob Jekyll on behalf of Mr. Allen, approaching the podium. Judge, on this matter, can we set both matters for an exam?
All discovery is complete. And would the people have their witnesses available on the 25th? Preliminary examination in these matters will be set for June 25th, 2024, 9 a.m. That is before Judge Barr.
There is one additional matter.
Of course there is. Go ahead.
I notified Mr. Kilwell last night via email that there were 2 calls that the defendant made to the victim after his arraignment. I requested that those phone calls be released to Mr. Kilwell last night. If he has not already received them, he should be receiving them shortly, but as a result, I will be asking for his phone privileges to be revoked today.
Judge, I have not received them yet. I haven't been to my office this morning, but that being said, Your Honor, I would just ask that I've instructed Mr. Allen not to make any phone calls to the parties involved.
When did these alleged phone calls take place?
The 9th, Your Honor, both on the 9th.
What calls case people versus Darian Crystal?
David I. Goldstein appearing on behalf of the defendant.
And pull your pants up. Next time wear a belt. You're in court. Understood?
Yes, sir.
State your name.
Darren Crystal.
All right. What are we doing on this?
Your Honor, I was just retained in this matter earlier this week. I do have some discovery, but I cannot say that I have the complete discovery. So I'm asking for a 1-week adjournment.
I give you 2.
That'd be fine, Your Honor.
At this point, Mr. Goldstein, I believe, should have everything that we have. However, I did make a supplemental request to the sheriff's department earlier this week because I do think that there was an additional audio recording and supplemental report from the defendant's arrest, which was listed under a different incident number. So we do not have that in our possession. I also want to make Mr. Goldstein, as well as the court, aware that there is a warrant that has not yet been reviewed that was submitted for Mr. Crystal for a controlled substance related offense. A charging decision has not yet been made on it. It was submitted to our office on April 24th. I just pulled it from the queue this morning and we'll be reviewing it today to make a charging decision. I will let Mr. Goldstein know what that charging decision is. At this time, I have not even read the report yet, but there is potentially an additional case coming for Mr. Crystal.
Your Honor, I was aware of the potential of that charge. That's something that happened long ago. So it's not something that happened since he was charged in this matter.
Okay.
That is correct. It was submitted to our office prior to this case. The offense date on this case that is in front of us today is June 5th. So it does predate that.
Got it. June 27th, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Brian Pinnerman.
Can am I heard, Your Honor?
Yes, sir. Go
Okay,
ahead.
this is James McWhale, Special Assistant Attorney General on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Finnerman, who I believe was supposed to be here via Zoom today.
I don't have him. He's not signed in. Uh-oh.
Your Honor, I'd asked, I spoke to him Tuesday evening. We submitted the Zoom request. My office contacted him. He said he had the Zoom permission. I don't know if there's some mix-up. I'd ask the court for a potential, perhaps a show cause or to pass this matter to see if I can reach him on the phone.
No. I don't. He was supposed to be here. We've had a failure to appear before also in this case, and he's now not here again. How much child support is owing?
This matter, Your Honor, a little over $8,500.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $8,500 cash. That warrant will issue immediately.
Thank you, Your Honor.
Thank you.
Your Honor, does the court prepare its own bench warrants, or do you want us to do it?
We take care of that.
All right, thank you.
Calls the case, People versus Israel Crane.
Read in this matter. Warren Brown, Deputy Chief Public Defender, affirm with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
To the best of our knowledge.
People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother. I do want to note that I don't see I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on a daily basis.
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yeah.
But the content of those particular phone calls, we don't know.
I have not.
Mr. Brown, I'm not sure what
I think they're asking for his phone privileges to be revoked, but
they haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out.
Here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third party contact. So maybe if you get a statement from the officer as to how they know that, what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture to handle it.
Thank you.
Okay, thank you. Court does call the case People versus Dondra Washington.
Morning, Your Honor. James Muckwell, Special Assistant Attorney General on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Washington, who approaches. And Mr. Washington, can you please state your name for the record?
Thank you.
Your Honor, we have submitted a waiver form to the court.
All right. Sir, it's correct. Do you wish to waive your right to a preliminary examination?
Excuse me?
You want to waive your right to a preliminary examination?
Yes, sir.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. You understand that?
Yes, sir.
People also waive the right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thank you. Your Honor, we acknowledge receipt of information. We have a formal reading stand mute at this time.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 23rd at 1:30 before Judge Conkey.
July 23rd, 2024, 1:30, Judge Conkey.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case People versus Daniel Franklin.
Andrew Childers appearing on behalf of the people, Your Honor. Morning, Your Honor.
Oh,
Nicholas
boy.
Batista,
He's back.
requesting practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple, representing Daniel Franklin.
All right. Permission to practice this grant.
Good morning, Your Honor. Wendy Barnwell, P42505, representing Mr. Franklin on the charge from March of 2024.
The homicide. Yes. Well, the other homicide. Yes. Go ahead. All right.
State your name for the record.
Daniel Franklin.
All right. What are we doing?
I would like to ask for an adjournment in this case for further investigation and to investigate a potential conflict.
Ms. Barnwell, what are you intending on doing in your case?
I believe it's a completely unrelated case coming from a prior year, 2022. I do have paper discovery, and I just downloaded 3 out of 5 electronic discovery that were sent to me recently, Judge. I would need time for that also. We're asking for a preliminary examination, but I do need time to prepare.
And discovery is not complete, so
Yeah. I mean,
and furthermore, it wouldn't, and I guess this would, I would expect the public defender's office is going to withdraw, judging by my review of the police reports and the number of individuals involved in the older homicide. My question to the court, and you may not know the answer, in the event the PD withdraws, would the second homicide go to Ms. Barnhart, or could that potentially go to a different?
I don't know that, but it may very well, since the court's not involved in that decision, it may very well go to another attorney.
Okay. I was just asking.
Yeah. I think they try to do what makes sense, but I don't know what would make sense in this point. All right. How much time did you need? Either one of you.
I need 3 to 4 weeks.
All right.
That sounds good.
You don't know, do you? No, never mind. All right. Probable cause conference, then I'm going to adjourn. Ms. Barnwell, I'm not going to set a preliminary examination until discovery is all complete and everybody's had a chance to look at it, make sure that's the direction you want to head. So I'll adjourn the probable cause conference to the 11th of July.
I didn't hear you, Judge.
July 11th.
Thank you, Your Honor.
All right.
That's a good day, Judge.
July 11th, 2024, 9 a.m. Bond continued as to 9. Court does call the case People versus Adelia Leslie.
Commissioner for the people.
This is Mr. Overwaters.
Assistant Public Defender Hannah Apple, appearing on behalf of Miss Leslie. Miss Leslie, will you please state your name for the record?
Adelia Janine Leslie.
Thank you, ma'am.
Your Honor, we were unable to meet with Miss Leslie. We would ask for a brief adjournment. We could schedule a visit.
How long is that going to take you to try to set something up with her?
Your Honor, we will make it happen before the next date, 2 weeks.
That comes up on the 4th of July, is that right?
2 weeks would be the end of the month, but I have July 2nd, but why don't we do this? She's July 11th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you, Ms. Leslie. Court calls the case People versus Andre Williams.
That case had been assigned to Mr. Feaster. I did meet with Mr. Williams before this court date, but could I have one moment to ask Mr. Gananter a question, please?
Sure. It's just going swimmingly.
That was a productive conversation.
Yes.
Your Honor, we would ask for maybe a 2-week adjournment.
Probable cause conference will be adjourned July 2nd, 2024, 9 a.m. Bond continue.
And I will come out to see you before our next hearing.
All right. Thank you, sir. Court does call the case, People versus Donald Whitsett.
Edward Drukas on behalf of Donald Woodsett and Mick Branding at 1341.
Silvana Reed, Assistant Public Defender on matter 0777.
And what are we doing?
Your Honor, for our matter, I believe that we need to receive some video discovery before proceeding. If we could set this out to the next available date.
All right.
So we want to keep our case along with that case.
All right. And what's the status of the video? I mean, is it just that you have to receive it and then
Yeah,
look
it
at
is
it?
jail footage, so it should be able to be received quickly.
June 27th, 2024, 9 a.m. Bond continued. Both matters.
I believe a stern warning to my client would prevent any future phone calls.
Defendant's phone privileges, and you can certainly, Mr. Killerwald, make a decision of setting it for a hearing, but defendant's phone privileges are hereby ordered removed. This time, bond will continue in all other aspects. Calls the case of the People versus the Contriana Newbie.
Good morning, Honor. Jake Hill on behalf of Ms. Newby. Would you state your name? Tatiana Newby.
Thank you.
Judge, can we set this for?
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 25th. Preliminary examination in person will be set June 25th, 2024, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Court calls case People versus Byron Blair.
On behalf of the people.
Mike Getty, Assistant Public Defender on behalf of Mr. Blair, who's approaching on my right, Your Honor. State your name, Mr. Blair?
Byron. Blair, look this way, please. Go ahead. What are we doing?
Your Honor, there's about 4 other retail frauds and a trespass he's probably got enough time on. We're looking to, Mr. Childers and I have discussed a potential global. He has court on the 26th with Your Honor in 14A1. If we could adjourn this to the 27th, we may have a resolution to everything.
That objection, June 27th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Calls the case People versus Randy Keys.
Edward Drukas on behalf of Randy Keys. Your Honor, I did have contact with Mr. Keys about today. I'm not sure where he is.
Randy Keys, a response bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000 cash surety. That warrant will issue immediately. Court calls the case People versus Stephanie Schneider.
Edward Drukas on behalf of Stephanie Schneider, who is approaching.
Your name?
Stephanie Schneider.
All right, what are we doing?
Looking for a preliminary exam date, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 25th. Preliminary examination in person will be set June 25th, 2024, 9 a.m. That is before Judge Barr. Continue.
Thank you.
Court calls the case of the People versus DeAndre Brandon.
Good morning, Your Honor. Marie Penhut, Assistant Public Defender. Sitting in for if you will.
Morning, Your Honor. Marie Rosinski, seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Senior Assistant Public Defender Joy Gaines on behalf of Mr. Brandon.
Permission to practice is granted.
Thank you. Please state your name for the record.
DeAndre Brandon. Thank you. What are we doing?
Your Honor, we would be asking for an adjournment to review discovery that we just received.
Your Honor, I think that's appropriate. It's the first PC.
It does call the case People versus Teresa Johnson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson approaches, Your Honor.
Good morning, Your Honor. Marie Penhut, Assistant Prosecuting Attorney on behalf of the people.
Ms. Johnson, will you please state your name for the record?
Yes, Teresa as backwards.
Thank you.
Your Honor, I was not able to meet with my client. She refused to meet with us this week. It's my understanding, however, that she is undergoing competency in one of her other matters. I'd asked for an adjournment of a couple of weeks.
No objection, Your Honor. I have had an opportunity to discuss with counsel.
July 2nd.
Thank you.
2024, 9 a.m. Bond continue. Court calls case People versus is it Ruffian Brooks? Any Brooks.
Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Brooks is approaching.
Andrew Childers, attorney on behalf of the people.
Brooks, will you please state your name for the record?
Rafinha Brooke.
Your Honor, we're just asking for an exam date in this matter, on these matters.
Discovery is complete.
Yes, Your Honor, as far as we can tell.
Would people have their witnesses available the 25th? Preliminary examination in this matter will be set in person June 25th, 2024, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the case, People versus Gregory Williams. I think that's Mr. Golson. Gregory Williams.
I believe he's in the hallway. David I. Goldstein appearing on behalf of the defendant. There he is.
Your name?
Gregory Williams.
Next time, long pants.
Yeah.
All right, what are we doing?
Your Honor, likewise, I was just retained in this matter earlier this week. I do have some discovery, but I can't say that it's complete. So I'm going to be asking for whatever the shortest adjournment the court can give.
I do want to note that as far as our end, everything has been.
Okay, just make it the same day, June 27th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.